So welcome back dear students. Today we are going to learn what are the cultural and educational rights of minorities. Two articles, mainly 29 and 30, they are dealing with cultural and educational rights of minorities. You see, these cultural and educational rights are intended to protect the interest of minorities. The word minority is not defined in our constitution. It is neither defined in Article 29 nor in Article 30. But dear students, you must have read this Encyclopedia Britannica, either in the library or online. So Encyclopedia Britannica defines the word minorities, and according to Encyclopedia Britannica, the word minorities means groups held together by ties of common descent, language, or religious faith, and feeling different in this respect from majority of inhabitants of a given political entity. I am repeating this definition. According to Encyclopedia Britannica, minorities means groups held together by ties of common descent, language, or religious faith and feeling, different in this respect from majority of the inhabitants of a given political entity. Dear students, the fundamental rights guarantee basic rights to the citizens of India, and we have learned that there are 6 fundamental rights enshrined in our constitution, and Article 29 and 30 deal with cultural and educational rights of Indian citizens. The fundamental rights intends to preserve the culture of all minority groups in India. The fundamental right granted under Article 29 and 30 intends to preserve the culture of all minority groups in India. And our Indian society, as you know, is a composite, heterogeneous one, and its diversity is one of its strengths. And our constitution guarantees these rights to minorities so that the diversity of this country is preserved, and it provides avenues for all groups, including marginalized ones, to protect, preserve, and propagate their culture. Dear students, please open up your bare acts and see the language of Article 29. Its heading is Protection of Interest of Minorities. And this article is intended to protect the interest of minorities. Article 29, Clause 1 provides to all citizen groups that reside in India having a distinct culture, language, and script the right to conserve their culture and language. This right is absolute one, and there are no reasonable restrictions in the interest of general public in Article 29, Clause 1. And this is the first fundamental right on which there are no restrictions, and this right of interest of the minorities is an absolute right. And every citizen group that resides in our country having a distinct culture, language, or script, they have been given the right to conserve their language and culture. Suppose in Rajasthan, the puppet show is their culture, dancing is their culture. So Rajasthani minority groups are allowed to preserve their puppet dance, puppet show as part of their culture. Similarly, language. If a particular group has a particular language, then that group has a right to preserve and conserve their language also. Second part of Article 29 imposes certain duties on the state. It says that state shall not deny admission into educational institutes maintained by it or those that receive aid from the state to any person based only on race, religion, caste, language, etc. And this right is given only to individual citizens and not to any community. Suppose there is an educational institution receiving aid from the government or educational institute is totally maintained by the state or partially maintained by the state by providing aid, then it is a duty of the state that they will not deny admission into any such educational institution maintained by the state or aided by the state. What is the restriction? That they shall not deny admission to any person only on the ground of race, religion, caste, or language. And this right is given only to individual citizens and not to any community. To illustrate this concept of cultural and educational rights given to citizens of our country by our constitution, we'll take the help of few leading cases and their ratio, decidendi, given by the apex court, that is Supreme Court of India. The first case before us is Jagdish Singh Siddhanti versus Pratap Singh Daulta. This case was decided way back in 1965 by the Supreme Court. In this case, the appellant, Jagdish Singh, he was a winning candidate in election and he was alleged to have used corrupt practices to promote enmity between Hindus and Sikh community, which was prohibited under Article 123, Clause 3 of Representation of Peoples Act 1951. There were mainly two allegations against the appellant Jagdish Singh. Number one, the appellant took the help of Hindi agitation and agitated that respondent was an enemy of Arya Samaj and Hindi language. And second allegation was that appellant used Om Dhwaj, झंडा होता है बहुत बड़ा, Om Dhwaj in his meetings. Now see the judgment of the High Court. The High Court accepted the contention of the respondent and set aside the election of the appellant. He filed an appeal before the Supreme Court and Supreme Court allowed the appeal and held that the right to conserve the language of citizen includes the right to agitate for protection of the language also. And political agitation for conservation of language cannot be regarded as a corrupt practice. Cannot be regarded as corrupt practice. And Article 29, Clause 1, which is an absolute right, is not subject to any reasonable restrictions. So see, Article 29 was interpreted by the Supreme Court, which gives you a right to protect your language, your script, your culture, if you are belonging to any minority group. So right to conserve the language. If he is conserving Hindi language, then it includes the right to agitate for protection of the Hindi language also. If he is using Om Dhwaj, in which Hindi is illustrated, or if he is taking the help of Hindi agitation and saying that respondent was an enemy of Arya Samaj and Hindi language, so this does not violate Article 29, Clause 1, which is an absolute right. So Supreme Court allowed the appeal and his election was upheld, that there is no misuse while electioneering. Why? Because he has a right to conserve the Hindi language and he had a right to agitate for protection of Hindi language also. The Supreme Court said that Article 29, Clause 1, the right of minorities is an absolute right and no reasonable restrictions can be imposed on it. Then correspondingly, second part of this article says 29 clause 2. This relates to admission into educational institutions which are maintained or aided by state funds. And direction is that no citizen shall be denied admission in such institutions on the grounds only of religion, race, caste, language, or any of them. Dear students, if you look back to Article 15, we have already covered that article also in the previous lectures. Article 15 also prohibits discrimination against citizens on the grounds of religion, etc. But the scope of two articles is different. Article 15, Clause 1 protects citizens only against the state, while Article 29, Clause 2 protects citizens against the state as well as against anybody else who denies this right to the minorities. And there is one more distinction. Article 15 protects citizens against discrimination generally, whereas Article 29, Clause 2 protects only against a particular species of wrong, that is, denial of admission in the educational institutions which are maintained wholly or partly aided by the state. And finally, see the distinction. In Article 29, Clause 2, the ground, place of birth and sex do not find a place. And if you see carefully Article 15, then language word is not mentioned in Article 15. So what is the net impact if you read Article 15 and 29 Clause 2 together? So read with Article 15 Clause 3, Article 29 Clause 2 may not be availed of by males for seeking admissions in exclusively female institutions. But its protection cannot be denied to females in all men's institutions. To put it simply, if female wants to have admission in co-ed educational institutions, then female can claim this right under Article 15. But if a male wants to have admission in exclusively female colleges, then Section 29 Clause 2 may not be availed of. The net result is that girls are entitled to have admission in co-ed colleges, whereas boys cannot take admission in exclusively girls' schools. This is the net impact of Article 15 Clause 3 and 29 Clause 2 with reference to minority institutions also. Dear students, we have another important case before us to understand this fundamental right of cultural and educational rights provided in our Constitution. And the case is St. Stephen's College versus University of Delhi, decided by Apex Court in 1992. And it was held in this case that a minority community may reserve up to 50% seats for the members of its own community in an educational institution established and administered by it, even if the institution is getting aid from the state. Supreme Court says that minority community who has established and who is administering an educational institution, even if it is maintained out of state funds, that minority community has a right to reserve up to 50% of seats for members of their own community in that educational institution. And the ratio decidendi of this case was followed again by the Supreme Court in TMA Pai Foundation versus State of Karnataka. In this case, while agreeing with St. Stephen College's ratio decidendi, the Supreme Court relaxed the 50% limit and has held that a reasonable percentage may be fixed by the state in which minority institution is situated. Supreme Court again agreed that, well, minority institutions do have a right to reserve certain percentage of seats in favor of members of that community alone. But that 50% cap was removed by the Supreme Court in TMA Pai Foundation's case. They said you can have a reasonable percentage of reservation for your own community in your own educational institution established and administered by you, the minority community. But 50% cap was removed by the Supreme Court. We have another very important leading case, State of Bombay versus Bombay Educational Society. This case was decided way back in 1954 by the Supreme Court. In this case, a Bombay government order directed the schools with English medium to admit only Anglo-Indians and citizens of non-Asiatic descent in the classes taught in English language. This order of the government was held to be ultra-virus. Why? Because this order denied admission to all people whose mother tongue was not English. So you are denying Hindi speaking students admission in your school because your school is English medium school. So this order of the government was held to be violative of fundamental right granted under Article 29 Clause 2. Why? The ratio decidendi is that you are denying admission to Hindi medium students only on the ground of language. You cannot do that. Because if you are denying admission to Hindi medium student in English medium school, you are violating the fundamental right granted to citizens under Article 29 Clause 2, because it is a direction for the state that they shall not deny admission to any person, any citizen, only on the ground of language. And in this case, Bombay government order says that Hindi medium candidates shall not be given admission in our school because our school is English medium school. Then this is an old case which we have read earlier also, State of Madras versus Champakan Devarajan. In this case, the Supreme Court invalidated special provision for admission to weaker sections of the society. This judgment was also criticized in legal circles. And then to overcome its ratio decidendi, the first Constitutional Amendment Act 1951 was passed, which added clause 4 in Article 15. And its effect is that nothing in Article 15 and 29 clause 2 shall prevent the state from making any special provision for advancement of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. Since in Champakan Devarajan, the Supreme Court had invalidated a special provision for admission to weaker sections of the society, so Parliament thought it fit to amend the constitution and to nullify the ratio decidendi of Champakan Devarajan, wherein the Supreme Court invalidated special provision for admission to weaker sections of the society, and now Parliament is authorized to make special laws for the advancement of socially and educationally backward classes of citizens or for scheduled caste and scheduled tribe. So, dear students, by this constitutional amendment, the state, that is the central government and the state governments, they are not empowered. They are now empowered to reserve seats in state colleges for any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. Then we have another amendment in our constitution, that is 93rd Constitutional Amendment Act, which introduced clause 5 in Article 15, which has no reference to Article 29 clause 2. And now because of this amendment, state can reserve seats for these classes even in private educational institutions, whether aided or unaided by the state. The impact of this 93rd constitutional amendment is that state can reserve seats for these classes even in private educational institutions, even if they are not aided by the state. So this preserves the right of minorities so far as their cultural and educational rights are concerned. Then, dear students, moving on to Article 30, and its heading is Right of Minorities to Establish and Administer Educational Institutions. This is the heading of Article 30. I am highlighting it. So, rights of minorities to establish and administer educational institutions of their choice. This right is given to minorities to form and govern their own educational institutions. Article 30 is also called as Charter of Education Rights, because this is the fundamental right even of the minorities, that they can establish and administer educational institutions of their choice. If you carefully see Article 30 clause 1, it says all religious and linguistic minorities have the right to establish and administer educational institutions of their choice. Choice is given to the religious and linguistic minorities, that they can establish and administer educational institutions of their choice. Similarly, clause 2, state should not, when granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. It is a duty of the state not to discriminate between different educational institutions while granting aid, because government aid, government money is all in all for autonomy of educational institutions. So direction for the state is that you will not discriminate, you will not give different treatment to different minority institutions while granting aid to them, on the ground that particular institution is under management of a minority, or a particular educational institution is based on religion, or it is based on language. State shall not discriminate. Before the state, all minority institutions are equal. Dear students, one of the biggest debates in our judicial history has been whether minority communities have right to autonomy or not while managing these institutions. And this question gave birth to famous decision of the Supreme Court in TMA Pai Foundation versus State of Karnataka, wherein it was held that in present times, the common consensus is that governments are allowed to regulate such institutes so long as regulation is in pursuit of ensuring academic excellence and it does not harm the character of minority institution. Supreme Court says that minority institution can have autonomy to the extent that governments are allowed to regulate such institutes so long as such regulation is in pursuit of ensuring academic excellence. If you are doing academic excellence, you can use this autonomy. And at the same time, your autonomy should not harm the character of the minority institute. Dear students, this leading case speaks a lot so far as the right of minorities to maintain their culture and educational rights is concerned. We have read this case earlier also, that is DAV College versus State of Punjab. In this case, Section 4 of Guru Nanak University Act. You see, all universities are established by the Act of Parliament. So, Guru Nanak University Act, its Section 4 enjoined the state to make a provision for study and research on the life of Guru Nanak and Punjabi language and literature. This Section 4 was challenged on the ground that since the university was maintained wholly out of state funds, Section 4 was violative of Article 28, 29 and 30 of Constitution. But this argument was not accepted by the Supreme Court because Section 4 was to encourage an academic study only on the life and teachings and preachings of Guru Nanak Dev, and which need not necessarily amount to religious instructions or promotion of any particular religion. And it was decided, it was held that Section 4 of Guru Nanak University Act is not violative of Article 29 Clause 1 and 30 Clause 1. Then, dear students, there is another question related with the autonomy of educational institutions, and that is acquisition of the property of minority institution who is running an educational institutes. You have acquired the property of minority educational institution, and the government has not granted requisite compensation to them. And very meager amount, very little amount of compensation is given to them. So it affects their autonomy because money matters. If the education institution does not have money, it cannot run it efficiently. So for protection of the cultural and educational rights of minority institutions, Article 30, Clause 1, capital A was added in it by 44th Constitutional Amendment Act 1978. And it says that in making any law providing for compulsory acquisition of any property of an educational institution established and administered by a minority, the state shall ensure that amount fixed by or determined under such law for acquisition of such property would not restrict or abrogate the right guaranteed to the minority institution under Article 30 Clause 1. If you are giving very little amount after acquisition of property of educational institutions maintained by minority, then indirectly you are taking away their autonomy because little money is being given to them. Their land has been acquired little money has been paid, how they will purchase land at another place at a very high cost. So the amount to be fixed should be such that it should not restrict or abrogate the right of that minority institution to establish and administer schools and colleges. Then, dear students, what is minority? We are talking about rights of minority. But what is a minority? The word minority is not defined in Article 29 or in Article 30. But minority primarily means any community which is numerically less than 50% of the population of a particular state as a whole. 50% of the population of a particular state as a whole. Later on, it was felt that numerical strength cannot be the sole guide in determining minority for the purposes of Article 30. And then, what is a choice? Minorities are given right to establish and administer educational institutions of their choice. So this right conferred on minorities is to establish educational institutes of their choice. It is left to their choice to establish such educational institutions as will serve both the purposes, namely, number one, that institute should serve the purpose. Number one is the purpose conserving their religion, language, or culture. And secondly, the purpose of giving a thorough general education to their children. They can have their choice, but these two purposes should be fulfilled.
कई लोगों को ये गलतफहमी रहती है कि हाइमेन एक कंप्लीट बैरियर जैसा है जो वजाइना को पूरी तरह से सील करके रखता है।
And dear students, what is the meaning of the word establish and administer? These two words must be read conjunctively so that minorities will have the right to administer educational institutions of the choice, provided that they have established it. Word establish means to bring into existence.
And in fact,
we have a very important leading case before us. S. Aziz Basha versus Union of India, AIR 1968, decided by the Supreme Court, cited at page 662. This case relates to the establishment of Aligarh Muslim University, Aligarh. It was held in this case that Aligarh Muslim University was established under Aligarh Muslim University Act of 1920. But the Muslim minority could not claim right to administer it. It is not necessary that whole community must be involved in the establishment of educational institution. Why? Because it may be established by a single individual with his own means in the interest of minority community. And all of us know that this great gentleman, founder, Sir Syed Ahmad Khan, he laid the foundation stone of Aligarh Muslim University by his own means. So it is not necessary that minority should be a group of persons. The institute may be started, can be started by a single individual like Sir Syed Ahmad Khan, who established Aligarh Muslim University. So this right of minorities does not mean that it should be a big group, maybe less than 50% of the total population. Minority means it includes a single individual who has started an educational institution for a particular minority group. They can start. And this fundamental right is available to such institutes also. So dear students, if I may sum up the fundamental rights relating to cultural and educational rights, I told you that Article 29 protects the interest of minorities, and any section of the citizens residing in the country, in our country, or any part thereof, having a distinct language, distinct script, distinct culture of its own, have the right to conserve the same. If I belong to Uttarakhand, the language is Gadwali. Every Gadwali has a right to preserve its own language. If they have a particular culture, they have a right to maintain the culture. As I gave you the illustration of Rajasthan, Rajasthani people have a right to maintain their puppet culture, dancing culture, singing culture. Yes, it is protected under Article 29. And similarly, the direction for the state is also contained in Article 29, Clause 2. And the present position of law is that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on the grounds only of religion, race, caste, language, or any of them. And so far as the rights of minorities to establish and administer educational institutions is concerned, my dear students, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Okay? And again, there is a direction for the state that while granting aid, while giving budget to the minority institutions, the state shall not discriminate while granting aid to educational institutions on the ground that particular institution is under management of a minority, or a particular education institution is based on religion or based on language. And very important part, I told you, 44th constitutional amendment also, by which clause 1A was added in Article 30. This is very important amendment, that when the government is acquiring the property of a minority educational institutions, government is bound to pay compensation. Government is bound to pay certain amount in lieu of compensation to that educational institution. And if that amount fixed by the government is too low, too meager, very little, then indirectly it will affect the autonomy of that educational institution. And if the proper compensation is given, well, you have taken the property from educational institution. That educational institution can purchase property elsewhere out of the compensation amount given by the government. But if the amount of compensation is very low, then of course it affects the autonomy of that educational institution. That's why by 44th Constitutional Amendment Act, this provision, Article 30, 1 capital A was added in our constitution. And dear students, I would like to repeat this ratio decidendi of S. Aziz Basha versus Union of India relating to establishment of Aligarh Muslim University, that even a single person can establish and administer any educational institution which is a minority. And in this case, Aligarh Muslim University was established under Aligarh Muslim University Act of 1920 by founder Sir Syed Ahmad Khan. So even a single person can establish a minority institution. So dear students, this is all about cultural and educational rights of minorities. Thank you very much.